Last week, the Supreme Court concluded 3 days of oral argument, 6 hours on Obamacare, and a week ago they argued the issue of the Medicaid and the severability issue. We'll talk about it today on Faith and Freedom. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. 3 days, a week ago, seems like a long time, but it's just recently. Of course, they're already now in the writing phase, but a week ago today, they argued the issue of Medicaid and also the severability issue. Now, in our case, Liberty University versus Geithner, we didn't have the Medicaid issue as part of it because that is only applicable to the states. But the states in the Florida case, the 26 or so states that joined together, obviously they're concerned with Medicaid. And it's not just those states. There's other states as well that have filed individual suits. Because in some states, the Medicaid rolls will balloon up to 50%. Mm-hmm. Medicaid is different than Medicare. Medicare is based upon your age. When you get to retirement age, then you are eligible to voluntarily select Medicare. Medicaid is for individuals before retirement age that have either financial or disability-related situations that qualify them for Medicaid. But what this will do is open the opportunities for Medicaid enrollment beyond what we have historically had as a eligibility requirement, meaning many more people will become eligible for Medicaid, thus ballooning the Medicaid rolls. And
some states are saying to a point that it will make them insolvent. They cannot afford to do this. And so that's another big issue beyond the individual mandate, beyond our states saying, here's the federal government overreaching, its tentacles coming into our business relative to Medicaid, forcing us to as you point out, to balloon the rolls at a tremendous cost to the state. What are we going to have to put on the chopping block in order to cover this? And there are states saying you can't do this.
Yeah, and in fact, take Florida, for example, which was the lead case in this Obamacare lawsuit on the Medicaid. Florida has 25 million people or so. It's the third largest state in the country. It's an elderly population, retirement population. But now all of a sudden you have Medicaid that's increasing substantially. And Florida depends upon tourism as one of its primary gross state products. And with the economy going down, everyone's suffering, so Florida suffers. And so they've had budgetary problems. They're not on the verge of bankruptcy like California, but there's a number of states that are on the verge of bankruptcy, literally on the verge of bankruptcy. Now you add this additional huge economic burden onto the states. The states can't handle it. They will go into bankruptcy.
They're already teetering, and boom, that just weighs them right into bankruptcy.
Yeah, I mean, if you're already having a hard time paying your light bills and you're barely making it from week to week, and now all of a sudden you have a huge additional financial obligation that's piled on top of you, it just pushes you off the edge.
You don't buy a summer home at that point.
Right.
You start cutting back.
And that's what this Medicaid provision does. So it will force states into bankruptcy, it will force states into insolvency, and it will have a ripple effect around the country. The other thing that it does, and one of the things that the states argued, and I think it's pretty good, is that this is not a voluntary choice. States can voluntarily choose to participate in Medicaid. I think Arizona was the last state to make that decision back in, 1985. So all states are Medicaid participants. So it's a combination between federal and state. What the federal government has done is they've redone the rules. Well, you might say, well, they can just simply opt out and just dump the Medicaid. It's not so easy because they've got all these people on Medicaid already. They would have a huge issue, and they'd have to phase it out over a period of time. But beyond that, here's an issue. They don't know what they're buying into. If the federal government says, I'm going to give you $500 million to a state for transportation, you can use it on roads and bridges, but in exchange, you need to have your speed limit at 55. That's a bargain that you are able to either reject or accept. I'm going to set $500 million. We're going to have our speed limits at 55. But if, on the other hand, they say, I'm going to give you $500 million, and I'm going to tell you what I want you to do with roads and other kinds of things, but I'm not going to tell you right now. and it's really up to me to make that decision. Well, you don't know whether to accept the $500 million as a state because you don't know what the string is attached to it. And that's exactly what happened with Obamacare. There's so many vague areas in here, so much discretion to the Secretary of Human Services that states don't know what they're signing on to.
Let me ask you this, Matt. Something else that was argued before the court on Wednesday was relative to this notion of a severability clause, and that's legal jargon. People may not understand what that is, but that says that a part of any legislation that is found to be unconstitutional can be severed, and the rest of the legislation remains good or in effect in force. There is no explicit severability clause in the language of Obamacare, so they're arguing whether or not, certainly probably the biggest implication would be the individual mandate. Is it severable if it's found unconstitutional? Does the rest remain in force? And then the big question is, if the individual mandate is severed, doesn't Obamacare sink under its own weight without the individual mandate?
Here's the best way to explain it. This is a stool with three legs. And up until Massachusetts with its health care and Obamacare with its health care, 7 states tried to build that stool with 2 legs. 7 states failed. Massachusetts added the third leg with the mandate, and Obamacare patterned itself after Massachusetts with the mandate, the third leg. The 2 legs are requiring coverage of pre-existing conditions. That's one leg. The other leg is prohibiting a community rating system. Basically, those 2 different legs expand the universe of coverage. You have to cover people with pre-existing conditions, and you can't make decisions to not cover certain kinds of categories based upon a risk management. So basically, that puts more pressure on the insurance companies and broadens out the areas of mandatory coverage. Well, 7 states tried that. 7 states failed. They repealed their legislation because it ultimately crushed the insurance companies. They left the state. They couldn't afford it. The 8th state came on the line when Governor Mitt Romney was governor of the state, Massachusetts. They added the third leg, and they said, well, in order to make this work, we're going to force everybody into the system through an individual mandate. Well, that is Obamacare on a small level. Obamacare then added that same template. So now, if you knock out the individual mandate, and you say, I'm going to sever that from the rest of the law, you've got these other 2 legs that are there. Guess what's going to happen on a national level? It's exactly what happened in the individual 7 states. The insurance system will implode. It will be a catastrophe. They will go bankrupt. And then what happens? Government comes rushing in and says, oh, we need to bail this out and therefore take it over as a single-payer universal health care system.
That's for sure, if the individual mandate is severed. However, people need to understand that the notion that Obamacare can survive even with that third leg with the individual mandate is absurd. The CBO is already coming out and saying it's already just in 2 years doubled from $900 billion as promised by Obama over 10 years to $1.76 trillion. It's already doubled. How long before it triples, before it quadruples? There is no way that this thing is sustainable. It is unsustainable. As I've often said, if you're carrying a big heavy load and you're getting ready to walk across a suspension bridge and somebody says, hey, that bridge is unsustainable, what do? Do you walk across it? No, because you'll plummet to your death. Well, Obamacare is unsustainable even with that third leg, that individual mandate. It is going to bankrupt America if it is not overturned in the Supreme Court or repealed.
That's exactly right. And so that's why I think it needs to be struck down and that it can't be severed. It is the motor in the vehicle.
Yeah.
You remove the motor out, and it may look like a car, but it doesn't act like a car. So when you remove the mandate, the entire system basically implodes on itself because the weight of the system will crush the insurance companies. So I believe, obviously, the mandate is unconstitutional and that it needs to be struck down in its entirety because it is so central and essential to the operation of this law. Without it, the law simply can't function. Go to Liberty Counsel's website, lc.org. You can look at our press releases that ultimately have our briefs that we filed before the U.S. Supreme Court on this issue on behalf of Liberty University and also 2 private individuals that Liberty Counsel has been representing for over 2 years now. And pray for this case because, as I said earlier this week and today, they're in the writing phase. This case right now is being written by justices of the United States Supreme Court. We don't know which way it's going yet. So it is important to pray for the outcome of this case. Go to Liberty Counsel's website, lc.org. Remember to pray for Liberty Counsel as well. As for our bumper sticker, Lord, deliver us from Obamacare, and also financially contribute to the ministry of Liberty Counsel. Remember to come to the Awakening 2012. lc.org is the place to sign up.